All right, good afternoon, everyone. Thank you so much for joining. I would like to point out that this is recorded, so it will be available online after the fact. It'll be available on our website and on our social media just for any questions. Let's see, anyone that is tuning in virtually, if you have a question, please drop it in the chat or raise your hand, which can be found at the top of your screen. I do not have the ability to unmute anyone. So if you need to be unmuted, you will have to do it yourself. Here with us is the amazing Nancy Harrison, and she is going to kick off our family law workshop.
So to introduce myself, I am Nancy Harrison. I'm an attorney out of Atlantic Beach, Florida. I practice exclusively in family law, and I'm here in conjunction with the St. Johns County Clerk's Office and the St. Johns County Legal Aid. So today we're going to talk about child custody. I've brought some statutes a statute for those of you present. I also brought a standing family law court order. We'll talk about the statute a little bit later for those of you online who can, find it on the internet, and the standing family law court order. So before we get started, child custody issues come up in paternity cases, they come up in divorces, and they can come up and be addressed in a domestic violence case when there's children involved. So let me start with some basics. The legal definition of child custody refers to the legal and hands-on relationship between a parent and his or her child. Custody includes the parent's right to raise, care for, and make decisions regarding the child. The natural state is for the child's biological parents to make all decisions involving the child's residence, healthcare, education, and religious upbringing. However, when couples separate, all of these issues may become contentious. When a child's custody and upbringing are in dispute, the custody laws and the court becomes involved and may eventually make a decision about that if you can't agree with the other parent. In Florida, the children's issues that are always on the table are parental responsibility, which is merely decision-making authority about your children. It does revolve around major decisions, so those are healthcare issues, education issues, and religious issues. If you have a particular issue in your family, the court could address that as well and add it. In Florida and everywhere, quite honestly, children's issues, come up with some negative things that happen, and some of those could be neglect, abandonment, false allegations made against a parent, and I'm going to use the term alienation, parental alienation, but we'll talk about that a little more because that's a term that is disputed between psychologists and experts in that area. So I've learned that unless you have an expert who's testifying at court, courts tend not to like the term alienation. So there's other words you can use as a layperson to bring it to the court's attention as well as the facts that fall into that. So negligence is when a parent fails to use their reasonable care, resulting in some kind of damage or injury to a child. Abandonment is just leaving, essentially. And typically that's going to be for a long period of time, not just, I moved out because we're separating and I've been gone for 3 months. In particular, if they're keeping in touch with the child or seeing the child, that would not apply. Abandonment usually follows with 2 or 3 years of not seeing a child, leaving a child. Even if they want a relationship, they just don't reach out and ask for the relationship. So some of those false allegations, which are very serious in family law cases, and they're not always false, but they are used for strategy purposes and payback and things like that. But those could be child abuse. Could be sexual, physical, emotional, which, you know, pretty much, if you can prove it, would show that a parent is unfit. Substance abuse, so shows that maybe you can't take care of your children. Domestic violence, whether it's just against a partner or it's in front of the children or against children. Mental illnesses, this comes up a lot. You know, when people have mental illnesses and they're treated appropriately, typically it wouldn't cause a parent not to be able to parent a child. But if it's untreated, it could cause pretty severe harm to a child who's watching the behavior. And then our alienation. So essentially the facts that would revolve around that would be, one, talking to a child or letting others talk about a parent to the child in a negative way, however that could be. A lot of things can be said to a child that could be deemed alienating, if you would, which essentially turns a child against a parent. And I've seen a lot of cases, and it happens. It's essentially psychological abuse, and a lot of the experts agree that it's child abuse. It has severe and long-term effects, and a lot of times parents never get that relationship back until the children are much older and they figure out what happened. Kids are very intuitive. So, and they're typically not happy because they learn that a parent has shut off another parent and they missed their childhood with that parent. So it can turn out in your favor eventually, but it's hard to deal with. Making false allegations. If you can't prove it, because that's what you got to do. You make the false allegation, you better be ready to prove it. And if you can't prove it and the court deems that you've made some kind of false allegations, they may not believe anything else you say during a hearing, a trial. So if you are going to make an allegation, you better make sure you can prove it. Courts are not, they do not look kindly upon that. Some people will call DCF for no reason. I've seen children today threaten that. And I've seen them call DCF because they don't want to do something. A lot of times it's for a good reason, but a lot of times it isn't. So, you know, why would someone do all this? It's payback, potentially. It's a fear, it's a strategy, and sometimes it buys them some bargaining power. You know, if you want the marital home, you've made this allegation, well, I'll give you the marital home and I'll drop this issue, which as attorneys, we know that was a false allegation. Let's see. The consequences of this could cause severe harm to a parent. It could affect their job, their emotional status. If they had a mental health issue legitimately, were treated appropriately, it still could affect that situation. So the terms that you should use in court, if you don't have an expert about alienation, is coaching. Coaching's a great one. I've had a case where the father was an actual coach for the, whatever it's called, the running part of the school and football. And he coached his children and he was very good at it. That's a term that's a layman's term. A court could hear that and understand based on the facts that someone might be coaching someone. These two terms, other two terms that I've found were not terms I've ever seen used, but one's triangulation, which is used to describe a parent who's purposely manipulating a child in order to gain power. Let's see. So those two terms are much better than alienation, because if you have an attorney against you and they object because you're not an expert, the court is going to sustain that. You're not going to get it in. So how do you fight these allegations? Because like I said, they have to prove it. So get all the details. You know, if you're the one being accused, send discovery to the other side. Tell them to tell you exactly what the facts are that support their allegation. And you can do that. There's rules in the civil rules of procedure that can tell you how to do that. An interrogatory is a written question that requires a written answer. So that's probably the better way to get someone to describe what the facts are. You can do a request for a production of documents. Maybe they have documents that might show that maybe some of that's true. You want all that because you don't want to walk into court as a pro se person who's representing themselves and not know what's going to be thrown at you. So you need to get that information. You could also take depositions. Even if you represent yourself, you have a right to take someone's deposition, which is really just a questioning of someone that's recorded. Write details about yourself, which would include calendaring your time sharing, making sure you write down what you did with that child during that time. You can take photos, keep text messages. Text messages can be very telling. Videos, as long as the kids aren't involved, you can probably do that. I have seen severe cases of alienation where a parent eventually will get out a phone because the other parent's standing in their driveway, screaming in the window, calling them all kind of names, while the children are standing around ready to go on their time sharing. And ultimately the parent says, "You're not going," after they cuss out the other parent. And now you have it on video, you can show it to the court. That's pretty devastating for the other parent and great evidence. Get medical records. If they're claiming you have some mental health issue, go out and get your records. There's nothing in my records that says I have this. Police reports, if they're out there, get them. Anytime you go to court, especially as someone who's representing themselves, you need to make a witness list. And I would start that early on with your case. If there's false allegations, find people who can disprove that for you, who can help you rebut those allegations. You can have witnesses that talk about how you are with your children, who've witnessed those kind of things. Those things will help you, rebut some of those false allegations. If they're making an allegation that you have a substance abuse problem, go get an evaluation yourself. They cost money, but might help you keep your children. So it's pretty bad. If it's a substance abuse issue, go get some drug tests. Take one every week for a little while, or get a hair follicle test. Those go back 6 months. Says a lot about you. If they're claiming you're an alcoholic, go get an alcoholic evaluation. An alcohol evaluation. You can do that. Mental health, get a mental health evaluation. They have evaluations to determine whether you're a fit parent or not. Ultimately, to get that into evidence, though, you will need whoever did it to come in so that you can get a document in. So you have to think about all these. You go back, add that person to your witness list. Child abuse, if you didn't do it, get your child examined. Take them to their pediatrician. Let the pediatrician look at them. You can get those records. Have there ever been instances where they had, unexplained bruises or broken bones? Go get those records. They're going to help you. Same thing for records like that. You can call what's called a records custodian to get those in, rather than a doctor, which will also cost you money to have them come. So like I said before, keep records, log your visitation, make notes from calls from the other parent. Keep your text messages, keep your emails, keep all those things. I have people come to me sometimes and something happened 3 years ago that was severe with a child. Where are your text messages? Well, I never back up my phone and I got a new phone and now I don't have them. You need to keep them. You may need them. You never know when you may need them. And in today's times, you can download them and save them to a computer if you don't want to put them in the cloud somewhere. Make notes about things your child says. You can't go into court with that. That's hearsay without an exception. So you can't testify as to what your child has told you. But again, if they have a therapist, they're talking to someone, it's possible you can bring their therapist in. So let's see what the kid says. Do they say these things are happening, or they haven't said anything about it? If you have valid concerns that involve all of these issues, put it in your petitions, put it in your motions. If you're going to bring some kind of proof about it, you need to make an allegation. And if you're making that allegations, there are some things that you might request that are slightly different than what a judge typically gives someone in a family where there's none of these issues. They have children together, they're getting divorced, or they're getting a paternity action to establish paternity. Because there are standards today, especially about time sharing, that you might need to rebut with your allegations. So same things, if you're making those allegations, keep records. You're gonna need them. Now, there are certain things that can sabotage your case, and I want to go over these because sometimes people who represent themselves aren't aware of it. My clients get speeches from me all the time. Sometimes they don't like me because I'm rather straightforward about things. So they need thick skin coming to my office. But you should always be aware, and we've talked about this in other sessions, but be aware that the minute you walk into that courtroom, the court is watching you. They're watching your behavior. They're watching what you have on. They're not looking for social status issues, but they are looking, if somebody's made an allegation that, that you're on OnlyFans and you're doing this stuff in front of the kids and you come in and call it a hoochie outfit. The judges are normal people. What do you think about that? First of all, it's not appropriate for court, so think about what you're wearing to court. If you are in a case, in a paternity case, domestic violence case, a divorce case, or even a modification of some kind of parenting plan, if you would never say it, write it, or do it in front of the judge, don't do it. Don't do it, because everything you put in writing could be read by the judge, and that could be devastating. And again, people video things, so just don't do it. If you wouldn't do it in front of the court, don't do it behind closed doors or in public. If you do those kind of things and they're recorded, you're also giving the other party a lot of ammunition to fire at you, which could make the court think that you're not very credible, and you don't want that, ever. Our judges are good here in St. Johns County, and they listen to the facts, and they will not, I like this party, I don't like this party. They will follow the law and apply it to the facts here. But behave. Another thing that can ruin your case, sabotage you, is don't move in with a significant other. It's not appropriate. You're in the middle of a case, whether it's, if it's paternity, it could be a little different if you haven't been living together, but especially in a divorce, don't put your child in that situation where they're having to meet a new person. It's hard enough for a child to come out of a relationship with their parents and have to move out than to now have this new third party involved. If you want to do that, whether you think I think it's a good thing or not, or anybody else think it's a good thing or not, wait until your case is over, because it won't be good for you. And definitely don't let any child call a third party mommy or daddy or any other form of parental notification. Don't do that. I just had a case where a judge was furious because a parent had done that. Their new spouse was telling the child to call him daddy. So when it comes down to it, In Florida, there is a public policy that, both parents have rights to their children. And our public policy in Florida is that both parents should be involved with the children. They should make joint decisions about the children, and they should have a lot of time with the children. So a lot of people go, well, I have this parenting plan, and it says ABC, and I'm not gonna let the other parent do this because it doesn't say that in my parenting. If somebody asks for some extra time and you don't have anything planned, and the child doesn't have anything planned, especially if you're in a pending case, do it. Let them see the child or children. Do it afterwards too, but it's also something the court's gonna look at. Are you voluntarily giving a parent time with the child? Maybe you don't even have a parenting plan yet. And we'll go over the standing family law court order, which tells you to do that here in St. Johns County. So that's our public policy in Florida, and a lot of people ask about child support. So child support, there's also a public policy that both parents are supposed to support their children. So don't complain when you have to pay some child support. All right, so I brought a statute here today, and for those of you online, this is section 61.13. And it deals with support of children, parenting, and time-sharing powers of the court. It's very important if you have a child custody case going on, because ultimately what the court's gonna do is look at the factors to find out what is in a child's best interest or the children's best interest. So look at it. I give it to my clients. There are factors, A through T. So I give these to my client. We're gonna go over them, but I will make them give me responses for each of those. Tell me how you do this, and tell me how the other parent does this or doesn't do it, because it will help in your hearing, because you have to go over these. And maybe it's just facts that you give the court, but there has to be information provided to the court, because typically the court is going to make findings about each of these. Before we get to that, I was telling you that we have parental responsibility. So in general, a court is going to give the parent shared parental responsibility, which means you have to make joint decisions. Now, does it always work? No, it doesn't. But a lot of people it's called parallel parenting, so they kind of have their own rules in their house and the other parent has their rules. And as long as it's not a big like educational thing, you're making some unilateral decision. Sometimes it works for people because they just can't get along, even beyond being separated. So, but the idea is to make those joint decisions. So you should be talking about big decisions. And some of it will be set out in a parenting plan, like education issues, but you are supposed to make those decisions together. Now, can I have sole parental responsibility? And I have people ask me this all the time. There's got to be something really extreme to get sole parental responsibility. There is something called ultimate authority making decision. That can happen sometimes on a particular issue. Maybe, let's say for instance, that a child is severely autistic, and maybe the other parent lives in another state. So for many years, one of the parents has been dealing with this issue, goes to medical appointments, goes to therapy, has them in a school that's good for them. So sometimes you might get convince a court to give you ultimate decision-making authority about their health care or education in a situation like that. But it's rare for that. Most of the time people get shared parental responsibility, so they have to make those decisions. The other issue in parenting issues in Florida is time sharing. So time sharing is the number of overnights you get with your child. Right now, under the law, the presumption is 50-50. So if you walk into court, the court is going to look at both of you and go, you're getting 50-50. So if you want something different, you have to rebut that presumption. So you need some kind of facts. These allegations we talked about that are false, they also could be true. So those may be some facts you could throw into the court and get, I don't know, an old school kind of every other weekend and then one night over the off weeks, rather than a 50-50 plan. And I wanted to caution you that if you have a young child, I find that younger children don't do so well on the week on, week off. That typically happens when they're a little older, maybe 10 or so, because the really young ones might have a difficult time. I'm talking infants to 3, 4, 5 years old. They may have a difficult time being away from a parent for a really long time. But you can set up plans that allow each of you to see that child, a few times a week. Once they're in school is probably about the time to start making that week on, week off, because they need some stability during the weeks. And then we have all these factors. So, in the child's best interest. So these are the things that the court must go through and make findings. So we're going to go through them a little bit because sometimes when you read them, you don't really know what that means. So what kind of facts fit into that? So the first is the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. That one's fairly straightforward. One, are they talking ugly about you in front of the kids? And a lot of times you can get that from the children. They're saying things to you that don't seem right. So ask some adults who might have been around. What was said? Who said it? Ask those questions. If you already have a parenting plan in place and you're trying to modify it, maybe there is a parent that won't let you see your children under the time sharing plan. So those are facts you can present. And like I said, if somebody says, hey, Olivia's got a birthday party to go to this weekend. I know it's your weekend, but do you mind if I take her to the party? Please let this child go to that birthday party, or else you've been rather selfish, in my opinion, to put yourself over a child's event that they probably want to go to. So keep records of those things. And I would suggest you take this out and write these things down, write your facts down. Because when you get in court, you're going to forget a lot of things if you don't write it down, make an outline, and have your facts and witnesses ready to testify about these things. So the anticipated division of parental responsibilities after the litigation, including the extent to which parental responsibilities will be delegated to a third party. So this would be a scenario. I know sometimes I have clients who live with their parents, which happens a lot now. So you have a child, a parent, a grandparent in the same house, and the parent's not involved. They're rather disconnected. So the grandparent is doing all the work. They're doing the parenting. So if you know that's going on, and most of the time you will, that's something you need to put before the court. The demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs or desires of the parents. So here's Olivia wanting to go to a birthday party, and it's just payback. I'm not going to let you have her to take her. So that's one scenario, not severe, where a parent is selfish about themselves, especially if they have nothing to do on that particular day. But look at those things, what kind of strange decisions have they made? I've had cases where parents will not do homework on their weeks, which is severe. Why didn't you do the homework? Well, I have these events at night and I go, I leave them with a babysitter and they're not doing the homework. Well, I'm sorry. That's your responsibility, and I'm sorry you have all these plans, but be at home and take care of those things. So those could be facts that fit in there. the length of the time the child has lived in a stable, satisfactory environment, and the desirability of maintaining continuity. So this happens a lot in a married couple who bought a home and that child has lived in that house for 6, 7 years. All their friends are right there. And then you have a parent, who moves 50 miles away and the child doesn't know anyone. So that could be an argument maybe for not a 50-50, but it is definitely something the court needs to know, because the court does find whether or not each of these factors favors one parent or the other. So if you're looking for a non-50-50 parenting plan, you need to get all this in front of the judge. So the geographical viability of the parenting plan, with special attention paid to the needs of school-age children and the amount of time to be spent traveling to effectuate the parenting plan. And this factor does not create a presumption for or against relocation of either parent with a child, which is a separate issue. But so I always caution my clients, I want to move 50 miles away, which they're allowed to do without court approval. But what does that do for your child? How long does it take them to get to school, especially if the other parent's home is designated as where the children go to school? So just things to think about, also facts to put into evidence. The moral fitness of the parents. In today's world, there's a lot of moral issues that a lot of people overlook. I'm sorry. People have affairs all the time. I see it all the time. It's just crazy to me. But write those things out. Those are things you need to present to the court. OnlyFans, I'm not sure that's appropriate, especially if you're doing it in your home and your kid's there. Because kids are nosy, they open doors. The mental and physical health of parents. Mental health, we talked about that a little bit. Physical health, if a person has some kind of disorder that they have a hard time taking care of a child, sometimes the court will put some precautions in place. And maybe multiple sclerosis that's degenerative and it's gotten to the point that you really have a hard time with that. They may allow, your parent, a grandparent, to assist you, which could negate this, I'm delegating some responsibilities to someone else. Because typically they're not going to hold that against a parent. But let's figure out how we can keep the children safe and cared for appropriately. That's how a court would look at it. So the homeschool and community record of the child. I love this one because a lot of parents don't know who their children's teachers are, who their friends are, what kind of grades they make, what their favorite toys are. This is a good one. So if you know all that, tell the court and ask the other parent. Ask them to tell you all that. Because a lot of them don't know. And that kind of shows they're not involved in what's going on with the children. So the reasonable preference of a child. It's rare that a court will listen, actually take testimony, if you will, of a child. Now, in Florida, children do not testify in open court. They're in what's called an in-camera kind of interview. So essentially, it is the judge and the child and a court reporter. You're allowed to have a court reporter present because ultimately the parties to the case, they need to know what the child said. But not in open court because it does pit the child against two parents, which is why courts are very hesitant even to talk to children at all. And 14, people always go, what's the age? Well, 14 is about when a child would be mature enough, if they're a mature child, to talk to a court. So the demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child. And this one goes back to the same thing about homeschool and community, including the child's friends, their teachers, their doctors, daily activities, and favorite things. And I know, at least when I had children, and mine are adults now, but A lot of time, one parent is taking the child to the doctor. They may not know that. They may have no interest in what's going on at the doctor, and they don't even know the doctor's name. So I know today's much more, parents are more involved most of the time with those kind of things. But find out if they know them. They may not know them. You know, what kind of activities is your child involved? What do they like to do? What's their hobby? Maybe they like crafting. The other parent doesn't even know it. Those are things you need to bring out. The demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline and daily schedules for homework, meals, and bedtimes. I ask my client, what's a day in the life of Olivia? What's her day like? Let's talk about a weekend. Let's talk about a school day. Because a lot of parents don't have that. You know, it's kind of willy-nilly, and you go to bed whenever you're tired, or when my TV show's over, I'll put you to bed. So those are good things to present to the court. And discipline, you know, when there's third parties involved, sometimes I have clients who want to make sure that there's no third party administering corporal punishment, and it's good to ask for that. Because sometimes you don't even know those people who get involved with your ex-spouse or a parent of a child. And how do you discipline the child? Tell the court that. The demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues with dealing with the child. So I talked to you a little bit about this parallel parenting, but parents do need to talk. I mean, kids are going to school, maybe their grades aren't good, maybe their grades are great. They have activities they're going to. Parents need to talk to each other about those things. And if you have a parent who refuses, the court ought to know them. Now, in today's world, a lot of times I like to use it, and the courts like to use it too, is a parenting app. There are two that are really big that the courts use a lot. One's Talking Parents, which is a free app, and there's Our Family Wizard, which is you have to pay for. But those apps allow you to put schedules in, communicate, and those communications are recorded forever. Your attorney has a right to look at them. You have to grant them access, but they have a right to look at them. And the court may request access to those, and they can read over your communications. So they never go anywhere. So like I said before, if you wouldn't say it in front of the judge, don't put it in the application. Just the facts is what I tell my clients. No emotion involved, and you'll be all right. But it also allows to put calendars in there. You could put in medical appointments, dental appointments, extracurricular activities, birthdays that your kid wants to go to. You could even put your time sharing in there on a calendar if it's a little more complicated than week on, week off. You can also download receipts and proofs of payments, of medical bills, of extracurricular activities, things that you're supposed to divide. I believe Our Family Wizard also has a transfer, a money transfer, a way that you could pay the other parent for medical bills that you owe a portion of or extracurricular activities. So those, I like those, and I think the courts like them because a lot of times parents don't do very well texting, and definitely not talking on the phone because those are not recorded. So people say a lot of things on the phone that they would not put in writing. And then you go to court, that's a he said, she said. So who does the court believe? The demonstrated capacity and disposition of each parent to provide a consistent routine. We talked about that. Sorry. We talked about that one. So, evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect, regardless of whether a prior or pending action relating to those issues has been brought. So, say there's been domestic violence in your home, it's very common for victims to not file for injunction, but maybe it's been happening and you can let the court know. The court can consider that even though you might have never called the police, you might have never filed a domestic violence injunction, but the court needs to hear it because again, we're looking at the children's best interest. So throw it all out there. Let the judge have it all. Evidence that a parent has knowingly provided false information to the court. So this is where you throw all your facts in about false allegations and how you prove they're wrong. Particular parenting task customarily performed by each parent in the division of parental responsibilities before the institution of litigation and during the pending litigation, including the extent to which parental responsibilities were undertaken by third parties. So this doesn't include daycares so that you can work or when the children are at school. This is more about the time that you spend with them when they're home and you work from work, not out partying. So what do you do? What do you do for the child? So you go back to that, a day in the life of Olivia. There's everything you do every day of the week. Get it into evidence. The demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. We've talked about this a little bit. Be involved in those things. You should be already. You shouldn't be involved because you have a pending case, but you should be involved. And if the other parent isn't, let the court know. The demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. So here's your false allegation. You're using drugs. Get your drug test. You can give them to the court and show that you do not have this substance abuse evaluation. You have this problem. Same thing for alcohol, and we talked about the mental health. So the capacity and disposition of each parent to protect the child from the ongoing litigation is demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the other parent to the child. This is a big one. I have parents sometimes who, they get to court and I'll ask them, does your child tell the truth? Well, how would he or she know that this case is going on? How would your child know there's a trial today? Well, I leave my paperwork out on my desk. Well, you have a 13 or 14-year-old, kids are nosy. So they may be looking at that stuff. Do not let that happen. Do not. You never want the court to even think that you've told your child something about the case. The developmental stages and needs of the child and demonstrated capacity and disposition of each parent to meet the child's developmental needs. So we all know as children age, they have different needs. And you need to let the court know how you are meeting those needs and how the other parent may or may not meet those needs. And some of these are going to be that both of you are doing the right thing. So, and you need to let the court know that. Don't always throw the other party under the bus if there really is no reason to do it. And then, like any other statute in Florida, there's always any other factor. So anything else that could be relevant to determining a specific parenting plan, let the court know. They want to know all those things. So those are the things the court will look at and make a decision that's in a child's best interest or the children's best interest, and you need to present facts about each of those factors. Some of them can be combined. You don't necessarily have to say this language that's in the statute. Just present the facts. The court will figure out what you're talking about and put them in the right place when making their findings. Now, I had a lot of people ask me this. Well, my spouse, former spouse, or the other parent is not paying child support, so I'm not going to let them see the kids. No, you are going to let them see the kids. In Florida, that is not a basis to withhold children from another parent. Is it a good thing? No, it's not. And if you have to file a motion for contempt for child support, you know, the courts look at that as it's disrespectful to them because there's a court order out there. They ordered you to pay it. And some lack of concern for your children because those funds are meant to support your children. They're not so, because I have people say this, well, she bought a new car. I know she's using my child support. Maybe she needed a new car, and guess what? All that money goes in a pot, and she's giving them a place to live, and she's feeding them, and she's putting clothes on them. That's what your child support's for. So just remember that. And I will say this, just an extra note on this. If you're the one paying child support, never pay cash. Please do not pay cash. If you want to use Cash App or something like that, you need to use something that's traceable. So you can go back if a parent says, well, they didn't pay me, and that you've handed someone, you know, over a year, $5,000 in cash. How do you prove that? Unless you get a receipt from them, which most people, you know, are not going to do today. Some other things I want to point out is, you know, don't damage someone else's property. I hear stories all the time. We see it in the movies, you know, they've left, they throw all their crap in the front yard and they burn it. Well, don't do that. Don't. It will not look good for you. And then we can go over this a little bit. Don't take your kids out of school without telling the other parent. I mean, you're both parents, whether you like each other or not. Work together. It's always good for your kids. And when you get to court, I've said this before in our other sessions, but you're telling the court a story. So make a timeline, stick your facts into this timeline, and when you get to court, you're representing yourself, you are telling the court a story about your children. So make it make sense, connect all the dots, easier for the court to follow, you know, bring photos, have all your evidence lined up the way you're going to tell your story. So once you hit this part of the timeline, it's time for you to give some evidence to the court. Always good to tell the court how the children are doing in school. Some people forget that. You know, maybe they're doing great, but you need to let the court know. And we can talk about modifications a little bit. But I wanted to point out that every time a family law case is filed, a new family law case is filed here in St. Johns County, there is a standing family law court order. So if you have a pending case, whether you were served or it was, you filed it, you should have gotten the standing family law court order. It is a court order. If you violate it, you could be held in contempt. But I want to point out, I make my clients read it because I've heard the judges ask if a party has read it in court. So I make sure my clients read it and we go over it together. But there are lots of this that involve the children. One, you've got to take a parenting class. That's important. You're supposed to have that done as soon as you get filed. Essentially, you'll have a case number, go get that done. You can get a list of the approved providers here at the clerk's office. Let's see, then we have, you can't remove a child permanently from the state of Florida without the written consent of the other party or without an order of the court. And if you're moving far, far away, you better contact an attorney or look at the statutes in Chapter 61. You've got to get the court's permission. Health insurance. Standing family law court order says if you're maintaining a child's health insurance on your employment insurance, you do not take them off. Do not. Now, if the other parent, you know, gets a new job in 90 days, they have better insurance, y'all can agree to swap the insurance. But you cannot just drop a child. You can't even drop a spouse. But don't do that. Don't change life insurance beneficiaries. Sometimes the children are named. Leave it just like it is. Don't touch it. These are things you can get in trouble for. If one of the parties leaves the family residence, and maybe you're not married, but you were living together, now you've got a paternity action going. You have to tell the other parent and this court where you've gone. I have that happen. I don't even know where she lives. Well, you don't have a time sharing, where are they? So make sure everybody knows. I've heard Judge McGillen get on to people they're required to file this notice of change of address. So get that done. Clerk can give you that as well. And if you don't live together and you have children, you have to assist the children in having personal, telephonic, written communication with the other parent. So I see that a lot, parents don't answer their phones for the other parent. Answer your phone. Even if you answer it and give it to your kid, or don't answer it, hit the green button and hand it to your child if you don't want to talk to them. But don't withhold that, because it'll come out. It's fact. It'll come out in court, and you don't want the court to hear that. So in the end, as hard as it can be in a contentious action involving children, play nice with the other side. You don't want the court to hear that you've done something you shouldn't have. That's about all I have. Any questions?
Yeah, we can open it up for questions. If anyone tuning in virtually wants to raise their hand or drop anything in the chat, feel free. And it can be about any family law topic. Doesn't
Right.
have to be specifically about child custody or anything like that. All right. Do you want to go ahead and unmute yourself? I'm sorry, it just shows as caller.
Hi, that's me.
Oh, perfect. Go ahead.
So I have two questions. The notice of change of address, mine is going to be for a divorce that happened in 2018. Do I still have to report a change of address, even though I've verbally, writtenly let my ex know?
With the court?
Would I still have to file that change of address with the court? Yes.
Yes. Even if your case is closed, you're supposed to file a notice of change of address in the court.
Okay, and what's the steps to doing that?
I think on flcourts.org, there is a notice of change of address there. So it's just a document that looks, just like everything else you file in the court, has your style at the top. It'll be entitled a notice of change of address. You just put your change of address in there. You do have to serve it on the other person. So, so he doesn't panic that you've opened the case back up. You might just say, hey, I'm just filing it with the court. We're supposed to do that. So I am.
Okay. All right, perfect. Yeah, we just moved probably like 3 months ago. And then as far as the topic of child support, like I said, this has been some time ago, and I did not, he doesn't pay me anything. That was agreed upon back then, and it was a major decision based on his life choices and my feeling of his ability to be able to handle something like that on top of the bomb that was dropped.
Okay.
So is there any reasons, just like with the custody changes, it's for like extreme kind of instances, but is there anything for the child support that they see as an ability to be able to change for? I'm not really sure how I'm trying to ask.
Yes. No, I know what you're saying. So you can modify child support, you can modify alimony, and you can modify parenting issues. So parental responsibility, time sharing. Now, all of those typically require some kind of change in circumstances from the time that your judgment was entered. But child support in the statute, which is 61.30, I think, don't hold me to this, but I think if the child support number increases by 15%, which that means in your scenario, if it's $15, then you would be able to modify it. So I don't know what the circumstances were then, but income changes and, maybe he's not exercising all his time sharing, you can always go back to the court for that.
Okay, so
And
the
those,
the
go ahead.
circumstances is there, sorry, it might be delayed and I'm sorry if I'm talking over you.
You're fine.
So the circumstances is that categorized into something a little more broad that I can then filter through if it applies to me or not, or are those circumstances limited?
No, I mean, I don't know if you're talking about income or if you're talking about time sharing, him not exercising it. Is it more about time sharing?
No, it's not the time sharing. It's more of income on his part. He's in a much better place. And I pay full every year for my son to be on my medical insurance. So every year I pay that, and every appointment that we go to, I pay for it. and
Okay.
and it's there's money that's given to me through my job for the family plan or whatever, but it's more so of he, to my knowledge, I feel that he has the better has the ability now to pay something,
Okay.
and it's that's mainly what it is. It's not, there's no change in my part. I'm financially,
Okay. You're financially okay.
yeah.
So let me ask you this. There's nothing in your final judgment or parenting plan that requires him to contribute to unreimbursed medical expenses?
Yeah, there's 50%. And there was this instance where he took him to the emergency room. And it turns out he told me he was taking him for chicken pox. And I'm like, typically you don't take them to the ER for chicken pox, but like, if you're doing that, here's, you have the insurance card. Well, it wasn't chicken pox, it was bug bites. So it turned out that obviously they charge you for the ER, even if it's something like that. And when that bill came in, it came to me. Well, when I mentioned it to him, yeah, I'll get you the money. Well, what happens? He doesn't get me the money. So push forward, and I'm looking to get a mortgage, and that is still in my history. So I call that collection agency and I flat out told them, I'm paying this much, but I'm not paying any more of it. I'm going to have to reach out to my ex-husband. Well, when I brought it up to him, he accused me of already giving it to me, and then I had just must not have paid and done what I was supposed to do with it. So I was very insulted and told him, never mind, forget it. I don't want your money. I will figure it out, and you know, all that. So he ended up giving me half in cash, and then the rest is still nowhere to be found. I'll never see it. So
Okay.
it's
Well,
just stuff like that, that it's not like an all the time happening, but if he did it once to me, if it presents itself again, he'll do it again.
yeah. So if I were you and you want to go after the child support, you just file a supplemental petition. You can find that on flcourts.org.
Okay.
And fill it out to the best of your ability. So say what's changed, if his income has increased. And quite honestly, if you're paying the health insurance, that is part of a child support calculation. So it needs to be included in that.
Okay.
Which doesn't give you a dollar for dollar credit, but it does give you some kind of credit towards, the equalizing of who's to take care of what for the children.
Yeah, and then that way it's at least something, and I don't have to, and I know I shouldn't, but back then I felt guilty. I felt like that it would basically put him in a situation that would affect our son, and I I don't know, I guess I intentionally didn't go after it and signed a waiver or whatever it was that I signed saying, that he would not pay me child support, because I didn't have confidence that he would be able to handle everything that was going on,
Well,
truthfully.
don't worry about him, worry about your children. So
Okay,
I would do it
supplemental
if I were
petition.
you. Based on what you told me, I would do it.
Okay, flcourts.org.
Yeah.
Yeah, and the form for that specific change of address is noted in the chat.
Oh,
You
thank
see
you. I will
And all of the forms are available at the, is it My Florida Court Access?
But it's flcourts.org. I think
Okay,
that is.
yeah, they're all available there.
Okay.
Yeah, every family law form you could ever need is there.
I'm hitting on chat and it's saying something went wrong, try later. Do you think they'll be available once we close out of this, or? I'm not familiar with Teams. I had to just
Okay,
What's that say, $12.95?
yeah, 12.915.
Okay, so it's form 12.915.
Okay.
But
And
when you go on FL Courts, you'll see where there, then it'll take you to all the forms. I'm not sure, they're not in numerical order, but you'll be able to find it.
I can control F it.
Yes, there you go.
Okay. Thank you very much.
You're welcome. You're welcome.
anyone else tuning in virtually have a question? No, I think that's still the same. All right, so I am going to turn the meeting off. Thank you everyone for joining us. Our next one will be December 4th at 12 o'clock in person and virtually as well, excuse me. So again, this will be recorded and available online by tomorrow morning. So if you have any questions, feel free to reach out to communications@stjohnsclerk.com. Thanks, guys.
Thank you.